Alex here with the Legal Nuts and Bolts video on unemployment appeals. Unemployment appeals is something that I have a lot of experience with, both for myself and others, helping other people. And I can actually represent other people. In fact, any non-attorney can represent somebody in an unemployment appeals case, but only up until the very end of the administrative tribunal process. So once it enters the district courts, you can no longer continue to represent the person that you're trying to help. It's tricky. They don't actually call you an attorney. They call you an authorized representative. It's in the Nevada revised statutes, and it's also in the Nevada administrative code. I'll go ahead and put it down in the description below. There's also an appeal that went to the Supreme Court of Nevada and published where an authorized representative tried to continue to represent the person into the district courts and beyond, and it went up to the Supreme Court, and they clarified that while a non-attorney can represent somebody, they cannot continue to represent them once it enters the district courts. So please do watch my video, Unauthorized Practice of Law. I do talk about some of the limitations that I and others who do not have the license to practice law have. But I also talk about some of the curious areas where, as a non-attorney, you can represent people. There's another area as well I talk about in that video. There's probably quite a few out there, I just don't know of all of them. So before I even talk about unemployment appeals, and then of course I'll talk about some of the cases that I helped with and represented people on. Again, I'm not an attorney. I want to stress that I'm not an attorney at this point in the video, just in case it's murky or confusing to some people. Anyway, before I get into all that, I wanted to talk about what unemployment is. Unemployment is actually formally known as unemployment insurance, and when you get money for being unemployed, those are called unemployment insurance benefits. Curiously enough, you have to understand that unemployment is not welfare. It is not for the needy, interestingly enough. And I say that with confidence because nowhere in the analysis of whether or not you get unemployment is your assets, your income, your lifestyle, where you live, your your property. None of that is taken into consideration by the agency. By agency, I mean the Department of Employment and Training Rehabilitation. We call it DETR in Nevada. The things that are considered have to do with your contribution to the workforce. So you could be a billionaire and collect unemployment. You could be the poorest person on the planet and desperately need the money, and you will be denied unemployment because they do not award the monies or disqualify you from unemployment based on those factors. As far as I know, the only thing that matters is, well, there's two things that matter. Number one is, have you been working? And number two is, why did you stop? And of course, there's little teeny tiny details that I guess I can go into right now. What I mean by have you been working, what matters is the duration of the employment and how much you were earning throughout that period of time. If you are working for a shorter period of time, you're still going to get an amount of unemployment insurance based on your salary or your wage or whatever, but it's not going to be for as long. It'll expire more quickly. At least that's my understanding. Again, these laws change, so make sure you do your own research. The dollar amount of the unemployment is based on, I'm not sure what they call this, what the formal name is, but what they do is they look at your past 5 quarters, and they take a percentage of that. I wish I could remember, something between 40 and 60%, but they don't take the average of the 5 quarters. They take the highest. So you may have earned 300 one quarter, 300 another, 500 another, and then you might just have this really odd quarter where you made, we'll say 3,000 or something like that. That's way up. They don't take the average or the mean. They take the highest. It's one of the things that I like to tell people. Some people, sometimes when they get terminated, end up making just as much on unemployment as they were at the point of termination, just because their income or their earnings were substantially lower, but they happen to have one particular quarter where they made a great deal of money. As I mentioned, the longer you are working, the longer you'll be able to collect unemployment. There is a maximum amount of time. I can't remember what it was because it changed when the 2008 recession hit, and there were a bunch of extensions and all of that were added into it that I'm not sure if they are still in place or not. I imagine that they still are. They usually don't take that stuff away. Once it's created, usually it just sticks around after the crisis, regardless of whether or not the crisis is still ongoing. If I'm wrong, again, please post it in the comments below. It's been a very long time since I actually had to look into any of this, because once I graduated, it was a very different story as far as staying employed. Is very easy now as a software engineer, software developer. There's a tremendous amount of demand out there. So this is just not an issue like it was when I was in college and when I was, in my early 20s, teenage years and stuff like that. So I may be rusty. So I've covered the duration. I really don't like to go into some of the myths, but I may as well, because there's a lot of myths out there. One of the myths is that they can sort of keep you from getting unemployment if you only work somewhere for a little while. As I mentioned earlier, there's no real threshold when it triggers. If you get terminated quickly, you will just not get it for as long. You'll get it for a very short amount of time. Labels. Sometimes people are worried about labels like temp worker and all that stuff. The law doesn't look at any of that. The law looks at your earnings. As long as you're not working for yourself, as long as you're not like a small business and you own it or something, as long as you're not a contractor, you're going to be entitled to unemployment. Regardless of what labels, and some people are concerned when their employer says they're on a probationary period or something like that. The law doesn't look at any of that. The other thing is sometimes people are worried about if your employer can sort of lower your hours but not technically terminate you. There's something out there called underemployment. Basically what it is it's you're making less working than you would be if you were on unemployment. So let's say you're earning, I don't know, $150 a week, which is really low, obviously, but you could possibly earn $400 a week if you're on unemployment. You're considered underemployed. So you can go and file for unemployment even though you're still working. You're allowed to do that. It's one of the things that they'll ask you on the, I know now they have an online system. What they'll do is they'll end up asking you how much, they'll go into all of the questions concerning how much you were making and stuff like that. In fact, I think they may get that in a report. I'm not sure. It may be automated as to them being able to get your last 5 quarters. But they'll ask you how much you're earning now and how much you're working now. And what they'll do is they'll give you the difference plus some kind of, I guess I'm going to call it a bonus. There's a name for it. Say you were entitled to $400 in unemployment benefits and you made $100 a week. Well, the difference of that is $300, but they don't give you the flat $300. They give you a little bit on top of that because they want to encourage you to continue working. They don't want to make it seem like, well, I would have made that money anyway, even if I took the day off. So you do still get, and you end up making a little slight bit more than you would be if you were completely unemployed. So going into the disqualifying factors, because that's the second part. The second part is, why did you stop working? I'm going to really not get technical in this video because I always stress in my other videos that all the other states may have different quirks and their case law may cover different nuance areas and rule on them in different ways. So I will give some nutshell overarching principles that appears to be consistent through all 50 states. If you quit, there is a presumption that you're not entitled to unemployment benefits, but you can overcome that. Unfortunately, I have zero experience in helping people get unemployment if they quit their job. But my understanding is that if they can show that they quit for some reason, that they can get it. And I'm going to give a few examples of some things that I think might work, but I've never actually looked into them. So obviously, if you were assaulted by a manager or something physically, that would be one way to quit and get unemployment. Potentially, if you could prove that you're being emotionally or psychologically attacked at work, that might be another reason. Maybe your employer promised you that you would be working 20 hours and then they started demanding that you work 40. I imagine that's some, if you give your employer, hey, I can work from this time to this time, and they're trying to make you work more, I would still say it would be safer to just refuse and have them terminate you, and I'll go into why later. Another thing that might work is if you find out it's some kind of criminal enterprise. Another thing that might work is if you resign maybe for some kind of severe illness or something like that where you're not able to work anymore, or maybe the workplace environment isn't safe. The point is you have to have some kind of reason, but you're going to have to prove it. The burden of proof is going to be on you since you resigned. Getting terminated is better when it comes to collecting unemployment. This is something that kind of shocks people. Some people out there think if you get fired, you can't get unemployment. Well, if that was the case, they'd just fire everyone. They wouldn't let anyone quit because Well, obviously, if you quit, you can't get it either. It's kind of a weird thing. I don't know why people sometimes believe that, but some people do. It's not true. If you get fired, the burden of proof is on the employer now. The employer has to show that they fired you for misconduct, and the burden of proof is on them, not you. Misconduct, that gets really hairy. A lot of times, people think that the employer can just kind of define what that means. They can't. Misconduct is defined by law. And so it doesn't matter what your employer thinks misconduct is or isn't. It matters what the law thinks it is or isn't. And if your employer fails to prove it, you are going to be entitled to unemployment benefits. I think one of the areas where there's a disconnect here is between employers and employees on if you were fired for a cause, you can't get unemployment benefits. If you were fired without cause, you can. Well, very few companies out there will legitimately say in writing, yeah, I fired this guy without cause. They always have some kind of internal corporate mechanism for why they're going to terminate someone. And so they always, from their perspective, terminate people for cause. But oftentimes, cause to them isn't actually misconduct under the law. Um, I think my examples will help a lot more than going into more technical details. Before I go, though, I do want to see what I can rule out as misconduct under the law. I want to mention one case. That's a Kolnick v. I can't remember who. Kolnick was a taxi driver who crashed his taxi, and he got written up. He signed a piece of paper saying that if I get into another accident, that I understand I'll be fired. He got into another accident, and he was terminated. And they tried to deny his unemployment benefits. Everyone agreed. It went all the way to the Supreme Court, and the Supreme Court disagreed, reversed, and sent the case back and ordered him to get his unemployment benefits. The reason why is they decided that you can't disqualify someone from benefits just from counting the number of accidents or mistakes that they make at work. You have to show that they're either doing something on purpose or that they're doing something negligently. People make mistakes all the time. You know, if they're doing things in good faith to the best of their ability at work, you can terminate them. It may be damaging to your business, but you can't disqualify them from unemployment benefits. And just because you put them through a write-up process and give them 3 or 4 or 5 or 10 or 20 or 30 chances doesn't mean that all of a sudden after some magic number, now it counts as misconduct. It's not misconduct. Some people try their best to make mistakes. And if they're making mistakes and you need to get rid of them because it's damaging your business, that's fine. But they're entitled to unemployment benefits. That's kind of what came out in that Kolnick case. Negligence, I really wish I could give good examples for that, but negligence doesn't equal mistakes, and you should really look carefully into what negligence is in your state and look at how the unemployment cases sort of were resolved when that was asserted by an employer, rather than me kind of just put that out there in a video, because that's another thing that's going to be something that different states might have a different perspective on. So the last thing I'm going to do is go into some of my stories. I'm trying to remember now the first time I collected unemployment, or it was like an ordeal. Oh, I have a few small examples that are really not that exciting. The most confrontational one was when I worked at Staples. Staples, just like any other sort of sales-oriented role where you're selling things in an electronics store, they check your numbers, and when your numbers aren't good, they don't like it. What I mean by numbers is not just the number of things sold, but also if you're selling like warranties and if you're selling like accessories with the products, those are big deals. They do typically, and this is something that's pervasive. No way am I going to say that this was just a unique circumstance that I went through. This is something that they all do. They follow you around with a clipboard and they get upset when you're not selling enough warranties to the customers and stuff like that. What they did in my case was they gave me a write-up saying that I need to sell more warranties, and then they dropped my hours a whole bunch. I responded by filing for unemployment, even though I was still working there, because as I mentioned, you can drop my hours as low as you want, but I'm still going to get unemployment if I'm not making as much as I would be if I was on unemployment. Underemployment is a thing. They responded by quickly reinstating my hours because they didn't want me collecting unemployment. After that, what they did was they tried to lower my wage, and that ended up backfiring on them for another reason. I may do a video on that as to why. After that, I ended up getting write-up number 2, and I think I got write-up number 3. So after I got write-up number 3, I filed my unemployment, and I claimed that I was terminated for not selling enough warranties and stuff. And I did the first step in this process is you get a phone call. And at that point, you are dealing with what they call a referee, unemployment claims referee or something like that. They may be called a hearing officer. It's either, I don't think they are. I think they're called a referee because the next level up is the appeals officer. So let's just go with that. If somebody finds out they're called something else, go ahead and post in the comments below. They just ask you a bunch of questions asking us to, what your job was, what you were doing at your job, why you think you were terminated, because they're going to ask your employer later. Or if you quit, you can tell them you resigned, and then they'll ask you why you resigned. And then they will also ask you how willing and able you are to get a new job. That actually is something I should have mentioned earlier. If you satisfy all of the previous conditions that I mentioned, but you do not demonstrate that you are able and willing to work going forward, you will still be disqualified from unemployment benefits. So it's important that you carefully analyze the way you're going to approach that question before you get that question. If you are in school, be very careful as to how you answer this question, because some of these referees will use the fact that you're in school to disqualify you from unemployment if they can show that you are not able to work a full-time job. What I have looked at in the past, my understanding is that if you can show you are able to work at least 2 out of 3 shifts, if you are available at least 66% of the time, you should be considered eligible for unemployment. I don't know if it's statutory, if it was just like a policy that they had. But if you answer, like if you're going to school or something and you answer your question, keep in mind that you have to answer that in a way that demonstrates that you are able and willing to work, and that you are available at least 2/3 of the time. If you have a child, they may ask you about that. If you say I have a child and I can't work because I can't get childcare, they're going to disqualify you. It would be much more appropriate to answer that question with more specifics as to, sure, I have a child, but I have some sitters, I may have a daycare optional, stuff like that. Make sure you are available at least 2 out of 3 shifts. Anyway, they asked me that question, and I explained my answer and everything. So they hang up the phone. By the way, keep an eye on your mail. You will get a notice telling you that they are going to call you and you are going to be asked some questions. And if you don't pick up, it can become extremely difficult to go back and sort of get another chance. It's very difficult to approach this and say, oh, well, I didn't know, I didn't get it in the mail in time, I didn't open my mail, because their perspective is you aren't working. So if you aren't working, you should be looking for work every day, and you should be checking your mail every day. You shouldn't be distracted. If you're not available for some reason and you miss the call, they're going to wonder why, because you shouldn't be working. You should be unemployed. So if you're unemployed, why'd you miss the call? They do take that approach. They're pretty aggressive about that. Anyway, what I was going to mention is after they call me, they call the employer. My employer said that I was written up 3 times and I couldn't, fix the problem, which was I wasn't selling enough warranties, selling enough products and stuff. And so the referee denied my claim. Now, I knew the law, so I filed an appeal. And when you file an appeal to the referee's claim, it triggers an appellate process within the unemployment system, which I'm going to go ahead and call the administrative tribunal. I believe that's what the courts refer to these as. Or the tribunal process, something like that. Because it's not in the court system. It's not there yet. There's a way to get there, but it's not there yet. At that point, it triggers an appeals hearing, which when I first started doing these, they were in person, and they did not like doing them over the phone. But now it's like they completely flip that, and they prefer to do them over the phone, and they don't like to do them in person. I don't know what that's all about, but you can still show up in person. So anyway, the appeals hearing was scheduled. I filed a detailed response citing a whole bunch of this, the case law and the statutory authority on it. I explained that under Kolnick, you can't just say you wrote me up 3 times. There's no magic number. I mean, nowhere in that process did my employer say I was doing it on purpose. Nowhere did they say I purposefully didn't sell enough printers. I purposefully didn't sell enough warranties. They were just saying that I couldn't do it for too long of a period, and because I couldn't, they terminated me. Like I said earlier in the video, from their perspective, if they have a reason or if they have cause, that should disqualify you. Well, that's not the law. They don't understand that. These managers and these employers, they don't understand how that works. They just think they need a reason that makes sense, business sense. But that's not how it works. You have to satisfy the statutory definition of misconduct. And that is not something that they can just sort of invent in their own head. So it went to an appeal. I went and I showed up, and my employer didn't I guess they read my brief and just chickened out. I got my unemployment, the decision of the referee was reversed and they reinstated my unemployment benefits. Another case, another one that I was involved in was a situation with a very small business that was trying to tell everyone that we were not employees, that we were all contractors. Well, there is a definition as to what an employee is, and the employer can't just label you whatever they want. The actual facts and circumstances of how you are employed matters. There was like, we would go in from 9 to 5. It was an office. We had a desk. We had a chair. We had a computer. We used their stuff. We showed up and worked there every day. It was a day job. We were not running our own little business contracted with them. We were their employees. They got pretty much everyone to sign all these things saying, you know, I'm a contractor and here's what I agree to and yada yada yada. But you can't just get around the law by just having somebody sign a piece of paper saying something that's illegal is true, or saying something that's inconsistent with the law is okay. If that was the case, you could just have somebody sign a contract saying, I agree to be your slave and you can sell me to other people. You can sign anything you want, but if it's not consistent with the law, it's going to get it's going to be deemed unconscionable. I have another video on substantive unconscionability and procedural unconscionability. Some great videos to look into. Anyway, that came up. I filed my unemployment after they went out of business, because they did go out of business. Filed my unemployment claim, and the referee contacted me, told them all, you know, gave them the whole gist. The employer contacted them and told them that they were out of business and we were all contractors anyway, and they sent in all the paperwork and stuff. And then I decided the law. There's actually a Nevada revised statute that expressly states an employee can't waive their right to unemployment benefits, and if you're an employee and you sign something saying you weren't, then that's just going to be deemed unconscionable. That's what happened, and I was awarded unemployment benefits. I ended up hearing something about the state going after them because they weren't paying their taxes on it, because they just thought that they were right about what the law was when they were completely wrong, and I think they've been chased around by the state and the federal government for doing that. So I also helped another friend with that. Only she had she had worse luck than I did. In her case, the referee ruled against her. And they said that because she signed a piece of paper saying she was a contractor, then she was a contractor. But I helped her with her appeal to the unemployment appeals officer, and the appeals officer ruled in her favor and reversed the decision of the referee, struck the contract, threw it out the window, and they said, you can call her whatever you want, but under Nevada's eyes, we think she's an employee, therefore she will be getting benefits. There was a few others, but I mentioned they weren't exciting. I'm going to go into the most exciting right now. This was a person who worked for a casino. She had to go and pick her daughter up from school, and she had to leave by the end of her shift to pick her daughter up, so it's not like she had to leave in the middle of her shift. Well, this casino got used to asking her to stay, and they asked her to stay several times. And they created what in their minds was a pattern that basically they thought they could hold her to. They figured that if she was able to get some kind of person to go and pick her daughter up from school 9 out of 10 times, then they can just force her to do it whenever they want. And they fired her once because she put her foot down and she said, I'm here 30 minutes after my shift. My shift is over. I have to go. She was a cashier. I guess they call them cage workers. And I guess they have some kind of rule that if your cage isn't balanced or something, you can't leave. Well, there's also the Nevada revised statutes, and there's also the law. So these casinos can invent their own internal policies all they want, but if somebody breaks a policy and the state says, you know, that's not misconduct because she left her shift on time and she had to go pick up her kid, then too bad, so sad, the employee wins. And that didn't actually happen right away. The appeals officer, or sorry, the referee ruled, wait, I think the referee, I can't remember now if the referee ruled in her favor. No, I don't think so. The referee ruled against her, and so she filed the appeal, and at this point I represented her. So I filed my, I think it's called the, it's like an affidavit authorizing representative or something like that, and she had to sign it saying that I know Alex isn't a lawyer, I want him to represent me as my authorized representative under the statute. She signed it, we filed it, and I was allowed to basically argue for her at the hearing. This hearing went well. I argued everything that I could. I didn't really make any mistakes, but the hearing officer ruled against me anyway. She does win in the end, don't worry. So after the hearing officer ruled against me, I helped her with the appeal to the Board of Review. And the Board of Review is basically, you could think of it like a second appeal almost. but they don't work like a normal court. They make a decision by panel, so they almost work like a panel, like an appellate panel almost. But they don't actually have to hear all the cases. My understanding is this: if the referee rules one way, and the appeals officer rules the same way, then the Board of Review can decline to even look at the the uh, the appeal to the Board of Review. They can just say, you know what, the referee ruled this way. The appeals officer agreed. We're just not going to look at it. They're not saying that they agree with the other two previous decision makers. They're just saying that we're too busy right now, and this isn't important. So we're just going to decline to look at it. But if the referee rules one way and the appeals officer overturns or reverses that decision, then an appeal to the Board of Review must be considered. Doesn't necessarily mean they're going to rule in the person's favor. It just means that they can't cop out. They can't just kick the can. They have to look at it and they have to make a decision. I don't know if this is still how the law works in Nevada. I'm pretty sure it is, but I do want to let people know that I've never actually seen the Board of Review do anything. All of the times that I was involved in appeals and all of the times that I've helped other people, the Board of Review declined every time. They just, I think that they only look at the cases they have to. I think when they see an opportunity to decline, they just decline because they just don't feel like it. Okay, once the Board of Review rules or declines to rule, either one, you can finally get access to the district court. Finally. And at that point, it's done by filing a petition for judicial review in the district court. Once that is done, you have access to the actual courts. As I mentioned, there is a case in the Supreme Court of Nevada that specifically states that at that point, your authorized representative has to get off. They cannot represent you in the district court. Only a licensed attorney can. But you can represent yourself. And the petition for judicial review is free. You don't have to pay a filing fee. You just go and you file it and they don't charge you anything. Once you do that, the district judge of whatever judicial district you're in and whatever department you're assigned to will read your petition for judicial review and either reverse the decision of everyone involved down in the administrative tribunal, or they will deny your petition and that decision will stand. My friend who got terminated for leaving work 30 minutes after her shift ended had her petition denied. I think that this is something that most district judges in Nevada do. I don't think that many of them understand anything about unemployment appeals. I don't think many of them even care. I think that most of them, when they see that you've already gone through an appeals process in a tribunal, they're going to take the lazy option. They're going to just kind of read over it, skim over it, and just deny it. So I prepared her ahead of time. I told her, expect this to be denied. Don't expect that district judge to care. Expect the Supreme Court to care. And that's what happened. She filed an appeal to the order denying petition for judicial review. That appeal opened a case in the Supreme Court of Nevada. The Supreme Court of Nevada found out everything that happened in the tribunal and the district court, and they decided that she should get a free attorney. So they gave her a free attorney, and they set oral arguments, which is rare. She and her free attorney showed up in the Supreme Court of Nevada. They basically called the employers a bunch of knuckleheads for trying to deny an employee's unemployment benefits when they left their shift on time to pick up their child. I really wish that I had the recording so I could kind of link you guys to it. One of the justices actually calls out the lawyer for the other side, and they're like, at some point you need to have common sense. It was just so, even they were disturbed. The Supreme Court of Nevada reversed the decision of the district judge, the Board of Review, the hearing officer, and the referee, and they gave her her entire unemployment benefit amount all at once. It was something between $12,000 and $14,000. She paid $0 in attorney fees. She paid $0 in costs. She just had to pay a lot in stress, but she did win. I think that's all. There's one more. Okay, this one's really funny. There was one situation where a friend of mine who was an attorney got fired, and she was working for an attorney. So she was an attorney and she got fired by an attorney. She filed an unemployment case. The referee ruled, I believe, in her favor. Yes, the referee ruled in her favor. That's right. And then and then her employer filed an appeal. I may have gotten that wrong, but I'm 90% sure that that's what happened. It doesn't matter. What matters is the end, which I'll go into right now. She asked me to represent her, which was really funny. And the appeals officer kind of asked, he was like, "You're not an attorney, but you're representing an attorney?" And he kind of looked at my the person I was representing, which was my friend, and she just was like, "He's representing me. I don't care that he's not an attorney." And so I, a non-attorney, represented an attorney against her boss, which was an attorney. That one I won outright. I don't remember what the deal was between these two lawyers, but he really didn't have her on misconduct. I guess he just didn't like her. She had a bad attitude or something, but he couldn't really state what it was that she did that was considered statutory misconduct. He was just trying to justify why he terminated her. Same mistake that many employers make. They try to give the reason as to why they why they terminated the employee, and they think just because they have a reason that that's good enough. Well, it wasn't consistent with the definition of statutory misconduct, and so the appeals officer ruled in my friend's favor, and she won, and that case just ended then and there. Her boss didn't do anything further. I think it's really crazy that that actually happened. So I suppose at this point I will end this video. Please post in the comments below if you have any questions at all about this. Don't be afraid to fight for your rights, and don't be afraid to get on unemployment, because it's not charity. It's not welfare. You're not taking money for being poor. You are giving that money because you contributed to the workforce. You are entitled to that money if you worked, and the amount that you're entitled to and the amount of duration that you get is based on how long you worked and how much you earned when you worked. It doesn't matter if you own houses and cars and have 100 grand in the bank, and none of that matters. They don't care. If you contribute to the workforce, you get unemployment. That's your reward for working hard. Look at that as a reward for being a hard worker. Don't look at it as don't take shame in any of that, because you're not going there with asking for a handout because you're needy. You're going there asking for some help so that you can find another job, because you've been terminated for reasons that are not misconduct. That's not your fault, and you have earned that money by working. By working, you have earned that money. I believe the maximum is somewhere between $400 and $500. I haven't checked into this for a long time. If anyone here knows what the new maximum is, look into it. But there are many other states that do give unemployment benefits to the poor, and they do look into their money and their assets, and they don't care if they've worked in the past or not. They don't care about any of that. In the UK, you can go in and get unemployment benefits just because you're not working. It doesn't matter if you were fired, if you quit, if you've never had a job in your life, you're going to get unemployment benefits there. That's because unemployment in the UK is welfare. And so that's why they look at your accounts and how much you have and all that. And there's another drawback to it. Because it's welfare, you don't get very much money. You get, I wish I could remember how much you get. I think they say it's like 65 pounds or something, British pounds, which amounts to like $100 a week. I don't know, something like that. Whereas in the US, you get around $500 a week, and that's because it's not welfare. It's given to people who have contributed to the workforce. Don't feel bad about it. A lot of people feel bad about it. I feel like if I got terminated and I didn't commit misconduct, I mean, I'm not saying that I want to, live, for free and not have to get a job in the future. I'm just saying I need a cushion so that I can find another good job. I'm going to need some time. I'm going to need a few months. I'm going to need a good cushion so that I can find a new job. Again, if you haven't held a job in your life and you are poor and you need money, too bad, so sad, because unemployment isn't welfare. They will not give it to people who are poor, because if you are poor incidentally or consequently, they'll give it to you, but that's not something that they analyze. They don't look into that. If you go in there and you say I have not a cent to my name, they're going to say, well, that's fine, but did you work, and how long were you working for? Oh, well, I've never had a job. Then you're denied. You don't get unemployment benefits. So I guess with that, I'm going to go ahead and end this video, and I will see you guys next time.